Okay, so it's a few minutes after noon, and we know folks have busy days. So we're going to go ahead and get started. We'll just introduce ourselves real quick. If folks would like to put their name and a little hello in the chat, you're welcome to do that. No pressure if you'd rather be anonymous. My name is Ann Webb. I'm the Senior Policy Counsel here at the ACLU of North Carolina. I've been with the ACLU of North Carolina for about 2.5 years. And my main job is, and I use she, her pronouns. And my main job is to, oh my gosh. Can you still hear me? Okay, great. Sorry about that, just a little technical difficulty. My main job is to work in the state legislature, and I'm going to pass it over to Daniel Bowes to give a quick introduction.
Yeah, good morning, everybody. My name is Daniel Bowes. I serve as the Director of Policy and Advocacy at the ACLU of North Carolina. I've been a registered lobbyist for about 9 years and spent the first 8.5 years at the North Carolina Justice Center as part of their Fair Chance Project, and started at the ACLU of North Carolina on March 1. So had the the unusual and interesting experience of jumping in at the, as a session's already gotten started, but glad to be working with Ann and glad to be here to update y'all on what's happening.
Awesome. So our plan here is to spend maybe half an hour talking about where we see things in the legislature at this point. And we'll give a little NCGA 101. And then we'll talk about some good bills that we're seeing, some bad bills that we're seeing. And then we want to leave tons of time for your questions. And we're also very open to receiving questions as we go. So please put those questions either in the chat or in the Q&A, and Daniel will be keeping an eye on those. And we really look forward to engaging in a conversation. So please do raise your hand and jump in and stop me if I'm going too fast or if you have any trouble hearing or anything like that. So like I said, we're just gonna do a quick NCGA 101. NCGA stands for North Carolina General Assembly. And here's the big picture. We have 120 folks in our House of Representatives and 50 people in the Senate. All of these members are up for re-election every 2 years. And the majority party controls all the main things about the agenda. So they assign committee chairs, they make decisions about what bills are gonna move forward and when. For the last about 10 years or so, that the majority party has been the Republicans. Right now, there are some key House and Senate leaders whose names are good to be aware of. House Speaker Tim Moore, and the Rules Chair, Justin Hall. And in the Senate, the President Pro Tem of the Senate is Phil Berger. The Rules Chair is Bill Rabon, and the Judiciary Chair is Danny Britt. And we'll explain later why we include the Judiciary Chair, but for our priority issues at the ACLU of North Carolina, that particular committee is very important to us. We'll come back to this later in the presentation, but I just wanted to make a note of the balance of power, the sort of breakdown between the Republicans and Democrats in each chamber. The main thing to know is that the Republicans, for a period of time, had what we call a supermajority, which means that not only could they pass any bills that they wanted by a simple majority, but they could also override a veto from the governor quite easily. And so for the last session, the last 2-year session and this session, that has not been the case. We have been in a position where the Governor Cooper, who's a Democrat, can veto a bill, and there are just enough Democrats in each chamber that if they all stay together, they can sustain that veto if it is challenged. So I will, I'll go into more detail about that later, but I just wanted to flag those numbers for you. So just a quick, just revisiting your Schoolhouse Rock for a second, just so folks can understand kind of where we are. All bills start, with drafting, and then they're introduced, and then they're referred to committee. Did I miss a slide here? Oh, no. Okay. And the bills go through committee, they're voted on there, and then they're considered on what we call the chamber floor, so the House floor or the Senate floor, for a vote. And if they pass one chamber or the other, then they go and they start back in the committee process in the other chamber. And what's important to know is that right now, a lot of bills are crossing from one chamber to the other, and I'll explain that in just more detail in just a moment. But we're kind of in this step 5 phase for a lot of important bills. Once the bill moves through committee in the second chamber, and it goes to a floor vote there, if the other chamber is happy with where the bill is, or if it's exactly the same bill that passed the other chamber, then there might be a quick concurrence vote, and then the bill goes to the governor. If there have been changes made in the second chamber, then there might be a need to go to a special closed door committee to work out those compromises, and then the bills go back to the chambers for a vote. If the governor has 3 choices when he gets a bill. He can take no action, in which case the bill just becomes law with no signature on it in a certain period of time. He can sign the bill, which is a sign of support, or he can veto the bill, and he has 10 days to do that after a bill is passed during session. If the bill is vetoed, and like I said, we'll go into more detail later, the bill can be brought back up in the chamber where it started for a veto override vote, and that can happen at any time from the time of the veto until the end of the 2-year legislative session. So just a quick review of kind of how the legislative schedule works. We have 2-year legislative sessions in North Carolina. So they start in the beginning of an odd year and they run to the end of an even year. So 2021 is the long session. That's the first year of the biennium. The even years are called short sessions. In the long session, the main priority is to pass a budget, but there are lots and lots of other bills introduced during the long session. The length of our sessions is not set in advance, and we don't have a specific number of days like many other states do. So what we find is that with the long session, we often see a very active time between about January and July, sometimes going to August. And then often there's a sort of a fall or winter reconvening in recent years to address a particular issue. And so this year we're expecting them to work on the budget in the summer, wrap up sometime in the summer, and then take a little break and come back to draw new district maps for the redistricting process that's happening with the new census data. The reason that we're having this presentation right now is because we just passed what's called the crossover deadline, and that was May 13th. Most bills must pass through either the House or the Senate and move to the other chamber in order to survive for the rest of the 2-year session. There are a number of loopholes and exceptions to this rule, so I just want to make sure folks are aware of that. For example, elections bills and bills related to redistricting and bills related to constitutional amendments, none of those bills are subject to crossover. So you may see a lot of elections bills that are going to be coming up that we haven't yet seen move this session, and that's because the priority has been to move bills that are subject to the requirement of crossover, and now some bills that are not subject to that are going to start moving. The other thing that can happen after crossover is that a bill that did meet crossover can be what we call gut and amended. So essentially the whole bill can be replaced with different content. And that is a way for leadership to get around the crossover requirement on a priority issue later in the session. I saw the Q&A popped up. Was there anything that folks wanted to ask about these
It was a question about the role of the lieutenant governor. And basically what I said is that it is now virtually completely ceremonial, though that person does preside over the Senate occasionally. And theoretically, there would be some use of discretion there, but we generally do not see that at all. I'm curious, have you seen, are you aware of any role in the legislative process for the lieutenant governor?
It's just tie breaking, right?
Yeah.
Yeah. That's it. Okay, so we're going to move on from our 101, and we're going to talk briefly about how the ACLU tries to engage in the legislature. We have a number of strategies. It's a little bit of a wordy slide, but we just wanted to give folks an idea of what it means that we have lobbyists in the legislature, and how we try to connect that to our work outside of the legislative building. One of our main and sort of primary goals and drivers in our work at the NCGA is to amplify and bring forward the voices of people who are directly impacted by the laws that are passed and discussed there. And so we do this in a number of ways. I'll give some examples as we go through the bills, but we are always looking for more opportunities to bring directly impacted people into the building, give folks the confidence to come and speak and share their own voices, communicate the views of folks who have shared those views with us directly with legislators. We know that it can be very difficult to engage with the legislature because they meet during the day, during regular business hours, and folks are working and are busy. And so we want to bring those voices in as much as we can. We also want to be a reliable and responsive source of information for legislators who frankly, don't have a lot of staff to work with. And so there are tons of bills being filed. There are lots of issues to learn and understand. And so we, on the issues that matter to us as the ACLU, we try to be present and available experts on anything related to civil rights and civil liberties that's coming up at the legislature.
And I'll just highlight that need, because I think that is what people miss a lot of times, is the need for good information. And even sort of tracking a bill that's in the other chamber or not before the individual's committee, basically just in some ways staffing the effort, really trying to get talking points, help them understand the background, what happened again in the other chamber. That's always a need. But especially this session, it seems like it's more of a need, and there is a little bit less coordination on the Democratic side, and so there's just more of a need of good information, and so that's a role that we are trying to serve.
Absolutely, and that's just a friendly reminder that we have a part-time legislature. The legislators, most of them cannot afford to do this as their primary job. If they can, then they're probably retired or have independent wealth. And we also don't give our legislators very much staff. So most legislators just have one person who can help them. And it's a lot of bills to keep track of and a lot of information to manage. So that's just a reminder that we continue to have that struggle here in North Carolina. The other thing that we try to do is to work in coalition as much as possible. Our goal is to sort of fill in the gaps, right? We cover a really wide range of issues, and where we see that there are not other organizations that are able to put time and energy into addressing a certain civil rights or civil liberties issue, then we put our focus there. We're also trying to, engage you all, the public members of our communities, on these issues as much as possible through our communications team. And then the other role that we play, I think, is kind of seeing what's going on in the insider politics around how powerful organizations like the North Carolina Sheriff's Association and the Conference of District Attorneys, those are our prosecutors, how they are engaging behind the scenes in the legislature to prevent a lot of really important reforms that need to happen from taking place. And so part of the role that we see is sort of shining some light on the way that those actors are preventing our state from moving forward. And we would just add that we're equal opportunity critics. We think that all leaders need to be taking responsibility for dismantling the carceral state and ending mass incarceration and other racist policies that we've had in our state for way too long. And so we have also been publicly criticizing the governor and other folks who have a role in maintaining that carceral state. So we can talk about that. We can answer more questions about that later, but I see a question in the chat about our stance on ending cash bail bonding in North Carolina, and I will, we can go into more detail about that later, but we have had an ongoing campaign to end cash bail, and we have litigation ongoing in one county, and we're eager to work with folks on reforming and really overhauling the whole concept of cash bail in our state. So I'm gonna take a deep breath for just a moment, and before we launch into an explanation of kind of what bills we have seen that have made it through crossover, and we're gonna start with the bad ones, and then we're gonna end on a high note. And just wanna preface this by saying that we do not want anyone to think that this is a comprehensive list of all the bills that made crossover. There are more than 400 bills that met the crossover deadline. And then on top of that, there are all the bills that were not required to meet crossover in order to continue moving. So I just want folks to be aware that we're just highlighting some of the sort of higher priority bills that we want folks to know about in certain categories that are our priorities. So here is slide 1 of 2 of bad bills that survived crossover. And I'll just, what I'm going to do is for each category, I'm just going to share a little bit about our, what we're seeing in terms of national trends playing out here in North Carolina, what our strategies have been on this area, and any other sort of outside factors that we think folks should be aware of. So in the anti-abortion space, what we have seen is there were, I believe, at least 6 anti-abortion bills were filed this session. The 2 bills that you see listed here are the 2 that have made it through crossover. SB 405 is the bill that it was the same anti-abortion bill that was filed and passed last session, and the governor vetoed it. HB 453 is a new to us bill that we have seen pushed in a number of other states. And we work in a really strong coalition with Planned Parenthood South Atlantic, NARAL Pro-Choice North Carolina, Sister Song, Carolina Abortion Fund, a number of other abortion clinics, and other advocates to bring providers into the General Assembly to meet with and talk to legislators, both in committee and privately, about what it means to restrict people's access to abortion health care. We also do a lot of public education about these bills, and we work really hard to help legislators learn how to talk about the bills. Legislators who support access to abortion often have a really difficult, it's very difficult to talk about these bills publicly. And so we put a lot of effort into helping them and us learn how to communicate effectively about these policies. The next category that I wanted to highlight is anti-immigrant bills. We have seen, a very strong and concerning trend of anti-immigrant bills being filed in North Carolina. What we've seen so far this session is reprisal of a number of bills that we have seen in the past. So last session, you might remember HB 370. We essentially just have that bill again in SB 101. That bill was vetoed last session. Governor vetoed it, and they were not able to override that veto. This bill will be moving to the House. It passed through the Senate, and it'll be moving to the House next. And we do have an expectation that it will move forward. The other anti-immigrant bills that are listed here, I just wanted folks to be aware of them. HB 62 did pass through the House, and it could go to the Senate. And there's another bill related to voting rights that we are determining whether or not the crossover deadline applied to it. So just to give folks a sense of that. And with those bills, we have helped to found and build a statewide coalition called the Statewide Immigrant Rights Alliance. And that group includes numerous, I would say almost 30 grassroots groups and other advocacy groups all over the state, from the west to the east. And we work together, we meet regularly to plan strategies, both inside the building and outside the building, strategies to stop anti-immigrant bills, to build community power in responding to these bills. And we're actually organizing a lobby day coming up for folks to come in and directly speak to their legislators about these bills. And we've also, whenever these bills receive committee hearings, we've brought folks in to share how they will be directly impacted by them. I included here, you'll see there's 3 bills under the anti-LGBTQ header that are crossed out, and that's because we understand that they are not going to move forward. And I'll just share a little bit of the story with these bills. So these are 3 bills that are anti-trans athlete or trans youth healthcare access bills. They are part of a deeply concerning national trend of attacking trans people, and especially trans young people, with legislation. We've seen a number of these bills pass in other states, and the ACLU at the national level is engaged in litigation to stop these really harmful pieces of legislation. What we saw here in North Carolina is that the first bill that's crossed out there, the Save Women's Sports Act, this is a bill that would have prevented young people and college students who identify as trans girls from playing sports on girls or women's sports teams. This bill did receive a hearing, and we worked in really close partnership with our friends at Equality North Carolina and the Campaign for Southern Equality and a number of other partners to bring directly impacted trans young people and their parents into the legislature to testify. And they gave very powerful and moving testimony about how harmful these bills would be. Even just passing them, was really stigmatizing and cruel. And so I think it was really moving to see those voices brought directly to the legislature. Fortunately, we have seen public statements from House and Senate leadership that these bills are not going to move forward. And the public sort of assumption and speculation is that there was a deal struck around bringing jobs to North Carolina through from Apple. So we are glad for the corporate input in a good direction in this case. And certainly that's a strategy that we and our partners have used and engaged in the past as well. The last section on this slide is what we're calling anti-history. And I think another word for these would just be straight up racist bills. This bill, HB 324, would in sort of short term, in as few words as possible, it would stop schools from being able to sort of full-throatedly teach about racism and the racism in our history at every level of public school. This bill is absolutely part of a national trend. There is sort of a conservative backlash against the concept of critical race theory, which is really just a way of understanding the racism that underlies our history. And we are seeing that here in North Carolina through this bill and a related Senate bill. So I think we should be keeping a close eye on that bill. We would be glad, we will save this chat, and hopefully we'll be able to reach out to folks afterwards with specific opportunities for engagement. All right, we have one more page of bad bills before we get to talk about the good news. In the anti-protest realm, and I saw a question from someone about HB 805, What we saw as a trend, so I'm sure folks have heard that around the country, in response to Black Lives Matter protests, there have been an extensive number of bills that attack protest in any number of ways, by criminalizing it, by discouraging local authorities from allowing protests to go on. And we saw at least 5 bills like that filed here in North Carolina this session. There were, I'll call it 1.5, well, really 2 bills that moved forward that sort of directly fall in this category. The most problematic one is HB 805. This bill was sponsored by one of those names you saw on the slide at the beginning, House Speaker Tim Moore. And I'll just flag for folks who aren't aware that it's very unusual for the speaker himself to file and sponsor a bill. So it's a signal that it's a very high priority issue for him. HB 805 does a couple of things, but the top line or the sort of bottom line of it is that it significantly increases the criminal penalties for engaging in a protest that that meets the definition under our laws of a riot. Our rioting statute is very vague, and so it is quite subjective as to sort of when a gathering of people crosses that line from a boisterous protest into a riot. And the way that this bill really seeks to quash First Amendment speech is by threatening folks with serious felony charges if anyone in a group that is considered a riot causes property damage or hurts someone. And so the real big concern here is that this bill makes it much easier to send someone to prison for quite a long time, a year or 2 or more, even if they themselves did not cause the property damage, if they were just involved in a group of people and someone else did that damage. So we are watching this bill very carefully. We're very concerned about it. And we wanted to just share very briefly sort of how it compares to a related provision in a Senate bill called SB 300. SB 300 is a bill that has, I believe now, 24 provisions in it. So it's not one that we have time to go through in detail. It has a number of sort of moderate reformist provisions in it around police reform and law enforcement. It was also originally filed with a similar bad rioting provision in its original version. It went through 41 changes before it got to the Senate floor. And in that process, the rioting provision in SB 300, which is now going to be going to the House, was softened in a way that, in fact, I think can be interpreted to be better than current law, in that it does increase the penalties for rioting, but it also makes it much harder to charge that charge, because it requires that in order to be charged with a felony for rioting, for property damage during a riot, you have to have been the one who actually caused the property damage. And that means that all the people who are around during a boisterous protest, perhaps a protest that goes past curfew, would potentially be at risk of criminal charges, but they would not necessarily be at risk of this much higher felony charge for serious property damage or injury to another person during that event. We will be watching that bill very closely as it moves through the House. It has a lot of attention on it and it has a lot of provisions. I wish I had time to go into all the other ones, but there are a number of other pieces to it, some of which are somewhat concerning. But in terms of the rioting provisions in that bill, it is much stronger language and a much better place for the community to land than what we see in HB 805.
And Carol, I saw your email in the chat about does H 805 have a real chance to pass? And yes, I mean, it is the signature bill of the speaker. As Ann said, it's unusual that he would introduce a bill or sponsor a bill. He's come down to the committees and vigorously spoken in support of it. So there's a real chance that it could pass, even with the provisions that it currently has, which, as Ann said, are highly problematic. Even there, it's still got 28 votes in support of it by the Democrats, and all Republicans support it in the House. Now, for the reasons that Ann just said, we think that there's a conversation going on where they can actually change 805 and basically adopt the conversation and the provisions that have been occurring around Senate Bill 300. And that's one of our strategies that we're exploring with partners. But for now, both Senate Bill 300 has passed the Senate and is alive in the House, and House Bill 805 has passed the House and is now alive in the Senate. So it really is, right now is the time for those bills to basically battle each other and see where things land.
And Sarah, I see your question about how to advocate against HB 805. I think the place to start right now is reaching out to members of the Senate who will be seeing that bill come before them next. And, I think it's also a good idea to reach out to members of the House who voted for the bill. They're also good folks to speak to because there may be changes made and the bill maybe come back to them. So those are the two ways to do that. And we could also pull our action alert off of the website if we had a moment, Daniel, and share that out. We'll absolutely follow up to this webinar with an email to all the participants with some of our action alerts and access to the video for folks to share with anyone who wasn't able to join. Thank you for all these good questions. Okay, so moving on to another meaty section, criminalization and racial inequity. We, every session, we see many, many, many bills that create new criminal penalties or make it harder for folks who have criminal convictions. And we just wanted to highlight a couple of these, and we've kind of lumped together this section with a bill that we believe contributes to the school to prison pipeline. And I just wanted to really, really strongly emphasize that this is a tiny fraction of the bills that we have seen filed and that are moving that create new criminal penalties or increase criminal penalties. We always see at least a couple of dozen every session, and it's a very concerning trend. The first one I wanted to highlight, this Standards of Student Conduct bill. This is one that we saw last session as well, and the bill looks like it doesn't do a lot, but actually it's deeply concerning. It tries to undo some language that was put into a bill that that advises about 10 years ago, that advises schools about when it's appropriate to use long-term suspension or expulsion for children in our public schools based on their behavior. And the language that they want to take out advises schools that they shouldn't be using long-term suspension or expulsion for behaviors such as foul language or dress code violations. And to be frank about it, the discussion that we've heard about this bill in committee has been deeply concerning because it appears that there are a number of folks who support this legislation who think it's okay to long-term suspend a kid, which we know from the statistics is sort of the first step toward engagement in either dropping out of school or winding up in the juvenile justice system, and frankly, just losing access to classroom time for learning. And they want to use these things for things like, what's termed disrespectful language or and I quote, wearing baggy pants or wearing certain types of clothes. And I think we can all hear that sort of racist undertone there, and it's very concerning. And so we just wanted to make sure folks are aware that this bill continues to move forward, and we saw it fail last session, and we certainly hope that will happen again. But there seems to be a lot of interest in it, and it's a very concerning one. The next bill on the list is HB 560, and this bill we also wanted to highlight because it's a bill that was put forward by the Department of Public Safety. It's what we call an agency bill. So all of the state agencies put forward legislation that they believe is necessary for them to complete their mission. Unfortunately, this bill, it seeks to penalize folks who are already incarcerated in our state prisons even more than they already are. By doing two main things. It creates new mandatory minimum sentences for folks who are already in prison if they violate certain rules. The one that has come up in this bill now a couple of sessions in a row is around adding as much as or at least 6 months to someone's sentence in prison if even one time they expose their private parts to a corrections officer. Now, we can all imagine that there might be a lot of issues that are coming up if that's occurring. And unfortunately, the response from the Department of Public Safety is that they want to lengthen the period of incarceration for someone who's engaging that behavior instead of addressing any underlying issues. The other thing it would do would be to make it harder for people who are incarcerated to seek redress if their property is destroyed or lost. The main reason we wanted to highlight this bill is because the Department of Public Safety is under the control of the governor. And the governor has engaged in a long process over many months in 2020 of bringing together a lot of stakeholders and legislators to come up with ways to address racial inequity in the criminal legal system. And that group, the Task Force on Racial Equity in the Criminal Justice System, put out a number of recommendations. And frankly, this bill directly flies in the face of all of those recommendations. It not only seeks to increase the amount of time that folks are in prison, it limits their due process when they are there, which is explicitly recommended by the task force. And it just sends the wrong message because we have very clear statistics that show that folks who are in prison who are Black receive disproportionate sort of punishment for their behavior while incarcerated than other groups of people. And so this bill will absolutely exacerbate existing racial inequities that we see in the carceral system. The bill is moving forward, and we hope that folks will engage with us in demanding that the Department of Public Safety sort of really walk the walk of the governor's values. The third bill I listed here, I just wanted to flag. It's a bad bill that we have good news about. The bill moved forward. It's called SB 693. And it started out with language in it that, if folks are following along, there was a bill last session called HB 918, which was vetoed by the governor. SB 693 had some of that same language in it, and that language would have made it easier to terminate someone's parental rights if they were using illegal substances during their pregnancy. And we're deeply concerned. We've been working with a lot of groups around the state who are working on harm reduction to stop criminalizing folks who are experiencing substance use disorders. And we were very deeply concerned about the racial inequity of parental rights termination as well. Fortunately, due to some fantastic advocacy and really amazing work, I think primarily from Senator Sidney Batch, the language in that bill was replaced with a much stronger bill that tries to address some of the process issues in our foster system and in our delinquency courts. And so we really are glad to see the language that punishes people who are experiencing substance use disorders removed, and we hope that it will stay that way as it moves through the House. So we have one last, not small, but it will be small for us category before we moved on to some good news. And this is anti-voting bills. And the main thing I wanted to say is that you may be seeing a lot of press about some really horrendous legislation that has been moving in Georgia and other states to suppress voter rights. And we have certainly seen a lot of voter suppression in North Carolina over the past decade. We have not seen the onslaught that other states have seen this year in terms of voter suppression laws, but we have seen a number of bad bills. And just to revisit what I said earlier, elections bills are not subject to the crossover requirements. And so we very much could see changes to the elections bills that have already been filed that take them either in a worse or a better direction. And so we really want to encourage folks to keep an eye out for our partners who specialize on voting rights. We really defer to Democracy North Carolina, to Common Cause, to the Coalition for to the Southern Coalition for Social Justice and Forward Justice, and other groups that are really focused on voting rights and these voting rights bills. So these are just a couple of the bills that we're following with our partners. But if you're looking for more detailed information about those, please do go to those partners for that information. We're always happy to help connect people who have questions. Okay. Any urgent questions before we move on to better bills? I see a couple of things in the chat. Send the link. Yeah.
Yeah, and I'm including in the chat right now a link to all of our take action alerts, and so whether it's on the not teaching critical race theory or 805, they're all at this link right there.
I see a question from Karen about where we can get more information on HB 247, and what we'll do is we work really closely with Disability Rights North Carolina on all the legislation that deals with kids in school and juvenile justice. And so I believe that they have put together a really good fact sheet on that, and we can attach that to the follow-up email. But you're also welcome to go and see what they have on their website, but we're happy to share that out with everybody. Oh, okay, perfect. All right, so some good bills, mixed news about them, just to prepare yourselves. Right at the top of the list, we are very excited to have seen a unanimous positive vote in favor of HB 608. The bill is called Dignity for Incarcerated Women. And this bill would significantly limit the use of shackling of people who are incarcerated in our jails and prisons who are pregnant. And we are really, really excited about this because it will, for the first time, create a standard for treatment of people who are incarcerated while pregnant at all of our jails across the state. And it significantly improves on the existing policy that the Department of Public Safety has for folks who are in our prison system. And it would prevent the use of shackles during the second and third trimesters, during labor and delivery, and during the immediate postpartum period, with some very limited exceptions. So we are thrilled to see it have such strong bipartisan support. It had many, many, many sponsors in the House, and it passed unanimously. We are excited to see it move in the Senate, and we hope that everyone will support it. And we're just really thrilled to see that moving. Another great bill that moved a little bit under the radar this session was SB 490, and we wanted folks to be aware of that. It'll be coming over to the Senate. It has bipartisan sponsors, and it limits driver's license suspensions for failure to pay and failure to appear to a maximum length of 1 year. And the reason this is so important is that folks who have been charged or sort of, been charged with failing to pay court fines or fees, or restitution, or failing to appear at a court case, can often lose their driver's license for a long period of time while they're trying to get that money together. And frankly, they have no choice. They have to go try to make the money to pay off the fine, but they can't drive to do that. And so it's really debilitating. And this will make it much easier for folks to get a provisional license, so that they can rectify that situation. The other bill here that I have crossed out, we just wanted to share in particular because HB 424 was a really great Republican-sponsored bill that would have ended what we consider to be the barbaric practice of sentencing children in North Carolina to life without parole for certain very serious felony crimes. And this is something that I believe we may be the only country in the world that does it. And we are among a narrow group of states that continues to sentence juveniles to life without parole. The proposal in the bill would simply be to give someone the opportunity to seek parole after 20 years in prison if they had been sentenced to life as a person who is under 18, I believe. We found that the Conference of DAs, the district attorneys, sort of the association of all of our state prosecutors who are elected, came out extremely strong against this bill. They spoke against it in committee, and it failed in committee and did not move forward. And we just really want everyone to understand exactly how the Conference of DAs is using and throwing its weight in the legislature against policies like this that have strong bipartisan support. And frankly, just raise these questions and concerns with your DAs. This is something that we all need to engage on. Another bill that we have seen, go ahead, Daniel.
Sorry, I just, if you don't take anything out, I mean, there's a lot to take from this, but I do want to highlight that trend that we're seeing where despite the DAs being asked to participate in the governor's task force for racial equity in the criminal justice system and sort of allowed to determine what those recommendations were, you know, that the conference itself has continually and aggressively worked to prevent a lot of the reforms that have either been pursued by Republicans, for example, what Ann was just talking about with H 424, which no other country engages in that practice. And, you know, the thing to highlight that Ann didn't mention was, you know, because it was sponsored by 4 Republicans, including John Faircloth, the former sheriff of Guilford County, that it had strong support and it looked like it was going to pass the House and become law. But it was stopped in its tracks, as Ann said, when the Conference of DAs came out so completely against it, based on, you know, exampling one case where they said the person, you know, was a monster and couldn't be reformed. Now, ironically, Representative Morey was actually the judge in that case and disagreed with how the conference was representing it. But whether it's that bill or several others, you know, what we've identified is a structural issue that has to change at the legislature for us to have any real progress, is that we have to take on the Conference of DAs and to basically lay their positions at the feet of the local elected DAs, because, you know, I don't think that they are really sort of willing to defend a lot of the policy positions that they've taken at the legislature. So I just want to highlight that, and thank you, Ann.
Absolutely. Thank you all for these great questions. I'm just going to check the Q&A real quick. Okay. So just one other bill that also highlights this same issue with the district attorneys is HB 912. This bill also has Republican primary sponsors. It essentially, several years ago, the Supreme Court stated that we could not execute folks on death row with severe mental illness. That's an extension of a previous ban on the execution of people with like serious developmental disabilities. And we need to set up a process to make sure that people with severe mental illness receive the hearings that they are owed in terms of determining what their mental status is. And we have seen opposition from the DAs, and this bill continues to move. It's not dead yet, but we are really looking for support from the community to help push that bill along. Okay, so just a few more, and then we will go to an open Q&A session. And these bills we've kind of labeled positive steps forward because there are some kind of mixed things about all of them, but we are glad to see them. The first one is a bill that would decriminalize non-statutory offenses. And what's meant by this is that when local governments pass an ordinance, let's say an ordinance against littering or an ordinance against loitering in a public park after a certain hour or something like that, those offenses can automatically become Class 3 misdemeanors in North Carolina, which means that someone ends up in the criminal court system over something that maybe should just be treated as like a ticket and like maybe a small fine at most. And so the idea would be to stop categorically making these types of ordinances criminal offenses in North Carolina. Unfortunately, so we've seen a lot of support for that concept. In practice, what we've seen in this bill is that it excludes all of the sort of most commonly charged crimes that result from ordinance violations, and those are mostly what we sort of inartfully call like crimes of poverty. So things that are related to homelessness or poverty, like some of the examples I just shared. And so instead they've narrowed it to only cover sort of things that aren't typically treated as misdemeanors, sort of other violations of like, local policies around how you keep your house or how you manage, things in your yard and things like that. And so we would really like to see this expanded to protect the most vulnerable people who are harmed by criminalized ordinances. But we are really glad to see the idea moving forward and would very much support moving this bill into law so that we have a baseline to work from going forward to improve upon. The other one is SB 301, which would expand expunction eligibility. Some of you may remember the Second Chance Act that passed last session, which expands on the opportunity for a lot of people to expunge their criminal records after a certain period of time. This would build upon that awesome work and expand who's eligible to people with 2 separate incidents of nonviolent felony convictions, which would be a great move forward. There are some concerns about compromises that were made in this bill. And so, we would really like to see some other things be part of it, but we're really glad to see that expanding expunctions continues to be a priority for the Senate. And I know we're running short on time, so I just want to flag one more good thing, which is we are seeing a lot of support for raising the minimum age at which a child can be charged in the juvenile court system. So right now, a child as young as 6 years old can be taken to juvenile court. This is really very similar to adult court, except there are some slight differences. We believe that children that young cannot and should not be held responsible in the court of law for their behavior. There are other ways to get them services, to get them mental health treatment, trauma treatment, to really address whatever underlying causes are of any behavior that rises to that level. And so we are thrilled to see a lot of movement toward raising that minimum age from 6 to at least 10 or ideally 12 years old. We saw a couple of Democrat-sponsored bills related to this get hearings in the House. And then we also saw a related bill in the Senate actually pass through the Senate. And so we're thrilled to see that move in the House. We hope that it will get lots of support, and that, you know, if it is changed, that it's only for the better, to make sure that those kids get all the services they need without being criminalized at a very young age. Okay, we made it. Does anyone have questions before I ramble on about veto dynamics for one more minute? I know we're getting to the end of our time. Is it right for DSS? I'm sorry, I don't know the answer to your question, Carrie, but we can connect with you. Okay. So just really quickly before we wrap up, a number of the sort of worst case scenario bills that folks may have seen get vetoed last session, or that we may expect to see vetoed this session, you know, we do hope that the governor will veto those. For example, we saw him veto the same anti-abortion bill last session. We expect he'll do the same this year. Sustaining that veto could be very challenging. There are narrow margins in both the House and the Senate. In the Senate, there's only a 2-vote margin. In the House, there's only a 4-vote margin. Sometimes I forget. I guess it's 3-vote margin. And so just wanted to highlight that we really need Democrats to stick together. We know that the Democrats in the House have had a little bit of a harder time doing that this session. So we encourage folks to pay attention to bills that are vetoed, and reach out if you are wanting to communicate with your legislators about sticking together on those issues. We are always available for questions. We would love to hear from members and folks who are interested. This is our team here on this last slide. And I believe that our information is back up on our website. And we will also be sending a follow-up email with contact information. So I'll be quiet, and if anybody, we have a few minutes left for any questions.
Hey, Ann, Mr. Harton asked about can you give more specifications on S377, removing foreign citizens from voting rolls?
Yes, so this is a bill that passed last session and was vetoed. It would essentially, so when someone is called to jury duty and they aren't actually eligible for jury duty because they're not a citizen, there's a form they can fill out and they tell the court, I'm not eligible for jury duty. This would require the court to share anybody whose name is on that list with the elections board, which would then be required to make that list public, and investigate whether those folks have tried to vote or are registered to vote. And our number one concern with this bill is that it would expose, so first of all, the data about whether someone is a citizen or not is very rusty. The federal databases that are used to determine someone's citizenship status are notoriously behind the 8 ball. They are not updated quickly when someone's status changes. And so to make an assumption based on that information is often incorrect and not up to date. So we are very concerned that vigilantes, which have done this in the past, may take those lists and go confront people directly in ways that could be dangerous or violent. We have seen sort of those kind of direct confrontations at people's homes in the past. And so that's what we are concerned about with that bill.
Another question we had was, any news on House Bill 914, rate increases for direct support professionals? I am not aware of that bill. Is that on your radar?
I'm sorry, I think that one might have been outside of our priority area.
Yeah,
but if there's a civil liberties concern there, we are always happy to hear that. So feel free to reach out.
And then Karen, and this is the last question that I see, Karen asked, how do we advocate for raise the age to 18? Could you talk a little bit about that in the context of just what's going on, I guess, with there was prosecutorial discretion and some other bills, but it's a lot of bills having to do with raise the age.
Yeah, so there's two kinds of raise the age, and it's confusing because last session we were working to implement raising the age of adult court coverage so that kids who are 16 and 17 would no longer automatically go to adult court. And so that has already happened, and that's great. We're implementing it. It's going really well. Right now, there is a big exception. 16 and 17-year-olds who are charged with higher level felonies above a class G still go to adult court. And there are some cases where prosecutors don't have discretion to just easily transfer someone back to juvenile court if that's a decision they want to make in a plea agreement. And so there is a bill that was moving to try to make sure that prosecutors have that option easily. And I believe that the House bill did not make it through crossover, but it's still possible that that issue is alive and that we could see it get added to another bill. The raise the minimum age that I was talking about as sort of the next phase of raising the age is raising that age from 6 to 10 years old for when a child can go into the juvenile court system, which right now covers children between ages 6 and 16. Does that answer a question? I hope.
I think it does.
Okay.
Well, Anne, since I'm your only sort of real feedback here, I want to thank you for doing a great job providing the summary. I will be taking the lead tonight. We're going to have a second update that'll cover some of the same bills, but just emphasize some dynamics a little bit differently. And that'll be from 6:30 to 7:30. So, you know, if y'all want to join again, you're welcome to, but it really is meant to basically cover the same things, maybe with a little bit different perspective and details added in. But thank you very much for joining us. I want to say thank you to Anne again for taking the lead on this and all the work and grind that she does in covering all these bills and ones that y'all don't even see here to give us the best chance to defeat them or amend them at the legislature. You know, we still have a couple months left at the legislature. So I would urge y'all to continue to invest your time, and we'll continue to send out action alerts. And I think one dynamic that I hope y'all get from today is that there are plenty of bills that still need attention, a lot of bad bills out there. We still have a radical conservative legislature in a lot of ways. But what we also need is, as much as you're contacting Republicans, we need you to contact Democrats and to ask your legislators to fight against some of these really bad bills and to stand up and confront the advancement, because a lot of times we're not even seeing the fight occur. And so that's a huge help that I think y'all can lend to this effort by paying attention and reaching out to your legislators. Any final things you wanted to say, Ann?
No, just it's really wonderful to see you all here paying attention to what's happening, and we hope you'll stay engaged with us because we really value our members engaging. So thanks so much.